SJC-10610, Commonwealth versus Fernandes.
Ms. Thurber, good morning.
Good morning. May it please the court, my name is Deidre Thurber, and I represent Odair Fernandes. Shall I assume that the court is familiar with the facts?
You can, but you're welcome to highlight facts you think we should
I will.
focus on.
Thank you. The first issue I would like to discuss with the court is the issue of the closing of the courtroom. As the court's aware, the Judge Hinkle, sua sponte, at the end of May in 2002, decided that she was going to close the courtroom. And she stated as her reasons, general courthouse security, an inadequate number of court officers, and overtones of gang involvement.
Don't we have to look at the entirety of the record for Judge Hinkle's reasoning? Because it had been mentioned at numerous pretrial conferences, correct?
She discussed it, but she never discussed any reasons beyond those.
Aren't those good?
No, because they're not case-specific. It's the general courthouse security has to do with...
But there were other specific issues with regard to this particular case, weren't
Not
there?
that she discussed, no. There were issues that Judge Locke on the motion for new trial came up as justifications, but all those reasons were reasons that came up well after the court made her decision to close the courtroom. He cited as justification, as potential reasons for why she had done this, that the fact that apparently there was at some point a difficulty in reaching one of the victim's mothers. That happened the day before she testified. She testified the next day. There was no mention as to what the problem had been. And I think that we can fairly well be assured that if there had been some sort of tampering or misconduct, that would have been brought to the attention of the court, and it was not.
Right, but Maldonado, which I believe was written well after this case was tried, correct?
Excuse me?
The Maldonado opinion was written, I think, in 2013 or 14, so this case was tried in 2006. So,
Correct.
So she would not have had the advantage of that, but it made clear you don't need to wait. You're not obliged to wait for something awful to happen.
But you have to have a reason to believe that something is going to happen.
Right.
And
Now,
Waller-
but that goes to Justice Gaziano's point. So, yes, it would certainly be better if we had findings all in one place, but do we not look to the entirety of the record to understand the reasons that caused her to do this?
Waller, which was written well before this case, very clearly states that there are 4 conditions, and they're not or, they're and conditions. Each one of the conditions must be met. The first condition being that there has to be a substantial reason. And this court has determined that has to be case-specific.
But can I go back to the case-specific then?
Sure.
I thought we have Cape Verdean gang concerns, right? That's case-specific, right?
Yes.
And we also have witnesses gone missing, right?
Well, that's the problem in the fact that Judge Locke didn't have a hearing on this. Witnesses gone missing are cooperating witnesses that were co-defendants that are friends and relatives of the defendant. There's no reason to believe, or nothing was ever put forth to believe that there was some sort of coercion or threats or intimidation that made these witnesses.
Let me just finish the
I'm
different
sorry.
fact. I also thought someone shot, right? One of the co-defendants is shot? Am I misremembering?
I think you're misremembering. This case arose out of...
So it's not accurate that a family member and/or the defendant one of the defendants was shot. Because that would be case-specific.
That's correct. There was...
Nothing about a family member?
There was the case originated, there was a shooting on the 17th of April, during which my client's cousin, relative, friend, Hamilton DeSoto, was shot.
Okay, so that's a family member who's shot, right?
Right, well, and that was, according to the prosecution, that was the reason behind the revenge factor for why the shooting happened on the 28th, April 28th.
Okay, but isn't there another family shooting later, or am I misremembering?
I believe you're misreading. There's not another family shooting of which I am aware.
What about the chances that the judge gave counsel below in the trial court to offer alternative suggestions or object?
They did object.
Well, not all the time, because she discussed this multiple times.
She did, and I mean, there was a standing objection. I mean, Mr. Sultan submitted papers in opposition, and there was even discussion about taking the matter up before the case went to trial. So it was very clear. The judge had no misconceptions as to where defense attorneys stood on the issue of closing the courtroom. It was very clear that they objected. I'm sorry, I completely lost the train of thought with
We're
that.
talking about the Waller conditions?
Excuse me,
The Waller conditions?
Oh, the Waller conditions, as I said, they are not and conditions, they are not or conditions, they are and conditions. And I'm sorry, Judge, you had asked me about alternatives, and I do believe at one point the prosecution suggested to the judge, because she was concerned about a lack of enough court officers, that there were plenty of Boston police officers involved in this case, and that they could be made available to provide additional security.
Isn't that really problematic?
Problematic in what way?
In that I could see a defense attorney saying, I don't want the Boston police who are involved in this case to be in this courtroom. This is the proper province of court-neutral court officers, as opposed to the Boston Homicide Squad who's going to testify in this matter.
Well, there were any number of police officers in
I would think a defense attorney that doesn't raise an objection
It
about that
didn't
would have a problem.
It didn't get to that point because the judge precluded that without any discussion. She never seriously
Probably
even
a good-
considered it.
Probably a good reason to do that, don't you think?
There was not a defense objection for me to be able to tell you how reasonable that defense objection was. It never got to that point. The judge just eliminated that possibility without any further, consideration.
Now, is there any consequence in terms of our review to the fact that Mr. Sultan, who's undeniably a very capable defense attorney, did not bring it up to the single justice?
I think it was just a question of timing and how much time between when this discussion happened and when trial was going to start and preparing for trial. This was, we just discussed very briefly with facts, this was, I think there's 10 days of testimony, if I have to estimate, I have it all written down, but I have
Right, but
estimated
there
there had to be
was- there
30
was-
witnesses who
It
testified.
wasn't as if, though, Judge Hinkle surprised anybody with this. There were discussions in advance, and I think she made clear her intention to impose this
The discussions
list.
did not start, I believe, until the end of May, and the case was being scheduled regularly, I mean, once or twice a week.
So end of May is the discussion began, and when was it, the case began trial?
I think
in-
began on the 20th of June.
Of June. Well, that's plenty of time. And again, does defense counsel, I mean, is it inconsequential that defense counsel chose not to prevent the problem before trial began, and then after trial is over, when it turns out badly, say, I was denied the right to public trial, and it should be reversed? I mean, is there,
I can't answer for why they chose not to. I have to assume in light
yeah,
of...
I'm not really so much asking why, I mean, Mr.
Well, I don't think-
But I'm asking whether it should have consequence in terms of our review of it.
No, I don't believe so. I believe that that the constitutional right for a public trial supersedes any question the court may have about whether or not defense counsel could have or should have taken it up with a single justice prior to. The right certainly precedes, or he's cloaked in that right for the entirety of the proceeding. So I don't believe that the failure to take it before the single justice should have any ramifications whatsoever, especially in absence of knowing what other things were going on with defense attorneys that made them make that decision. So,
I'm confused by, I'm going back factually. I'm looking at the motion judge's findings. 3 of Fernandes's co-defendants Enrique Lopez, Carlos Silvas, and Herr Fernandez had been shot at by the time Fernandez was indicted. During June 2003, Carlos Silva and Enrique Lopez's sister were shot at in Dorchester. Lopez's home was shot at. Then we've got, additionally, there were safety concerns for cooperating witnesses, and then another associate of Fernandez gang was murdered on the weekend prior to the protective order hearing. Individuals attending that hearing wore pins with the victim's face. So there's a lot of activity around this that, specific to this fight, right? I'm confused by why that doesn't matter.
That wasn't articulated by the judge as being a reason for why she closed the courtroom, and I'm unfamiliar with some of the facts that you've just recited.
Well, you shouldn't be unfamiliar because they're in the motion judge's findings, right? I'm just reading from them.
Okay. Well, again, these are findings made by the motion judge in the absence of a hearing. They were not flushed out. It's, for example, his recounting the fact that a victim's mother was not able to be reached. That sounds very ominous until you put it in context of the fact that she came to court the very next day and testified, and nothing was raised about why she had been unavailable the day before. I'm saying that these facts that are in the judge's decision are unflushed out facts. They weren't scrutinized. There was no cross-examination. There was no witnesses came forward and testified. I don't know that they're related to this case or not related to this case. And neither does the motion judge. So the bottom line of Waller is that if any one of the four criteria are not met, then the defendant was deprived his right to a public trial. And the defendant would suggest to the court that none of the criteria were met, that there was not a substantial compelling reason, that the closure was broader than necessary. She excluded everybody but people on a list, everybody. And there was even at one point a court watcher allowed into the courtroom to watch that was then excluded because the prosecution alleged that he
was acting inappropriately.
He acted inappropriately.
The judge doesn't have a discretion to throw Tony out when he acts inappropriately?
I think the first thing the judge should have done is instructed Tony not to do it, or else he risked being thrown out, rather than just, even when she noted herself that she had seen him in the courtroom on numerous occasions and she had never noticed anything, she still threw him out.
We're going to tell judges that you don't have the discretion to control your courtroom, and when a court watcher has a beef with a witness, we're supposed to give them a warning?
In light of the fact that the defendant is entitled to a public trial, yes.
Well, I mean, it was a partial closure, not a full closure. The press was there.
Well, it's interesting. I tried to research every case since the closure in this case, and this court only talks about partial closure when they're talking about a phase of the trial being foreclosed, like attendees not being allowed to be in the courtroom during voir dire, or attendees not allowed to be in the courtroom during the testimony of a minor witness in a rape case. This court has not.
It's been a while since I wrote Maldonado. Did I not refer to Maldonado as a partial closure? I thought I did.
Maybe, I'm not going to disagree.
Well, I mean, I've written a lot since then, but it does seem that was a case involving some restriction. In that case, all you had to do was to simply write your name, so that was a question you had to identify yourself. But we did require there to be a appropriate predicate for that. This is more than that.
Oh,
this was more limiting than that, but not a total closure of the courtroom.
No, for the defendant, he was allowed in his mother and his sister. That was it.
Did he ask for more?
Yes, he asked for more. As a matter of fact, if you attached to my motion for a new trial are affidavits from several family members, all of whom had tried to attend the trial and were not even allowed off the elevator. Never mind getting as far as seeing a court officer with a list.
Wasn't it pointed out that those that weren't allowed in the courtroom and were in the hallway, I remember reading, were intimidating witnesses when they were leaving the courtroom?
There was an allegation, and even the court recognized the fact that it was a second or third-hand allegation, those were her words, that there was some staring down in the courtroom. There was no mentions of gestures or threats or...
Staring down when they left the courtroom.
After they had testified.
Right.
So they didn't, whatever had happened in the courtroom, out in the hallway, did not interfere with what went on in the courtroom. And I would suggest to you, without further questioning of these people, what might constitute staring down to one person might not be anything intimidating when actually examined for what it really was.
Well, counsel, I'm a little confused because I don't understand where the motion judge obtained these facts then.
I don't either.
They're not you're saying they're not in the record?
The only thing that I'm aware of in the record is the fact that there was problems, and I went through the transcript last night, so pardon me if I missed something, but the victim's mother, one of the victim's mothers was unable to be reached. That's in the transcripts. The judge did mention, like on day 10 of the trial, that she had been concerned that cooperating witnesses were not able to be located to testify. There was the notation about the staring down in the hallways, but as I say, that was after witnesses testified as they were exiting, so.
So you're saying the motion judge is incorrect about the shootings of the
I'm
other
saying that-
people, and that's not anywhere in the record?
It's not in the transcripts as far as I'm aware. I believe that might have been information provided in the opposition by the Commonwealth, but not part of the record that I'm aware of. Not that I read.
Wasn't in affidavits or anything?
I can't answer that question, I'm not sure.
If I could turn you briefly to the issue of the sufficiency of the evidence.
Sure.
I gather that there was a threat by your client after his friend had been shot to obtain revenge, that he was the person who had rented the white van 4 days before the shooting, even though he already had a Volkswagen Golf. He was seen 1 hour after the shooting in that white van with two other individuals who had been identified as the shooter and as the driver. And in that van, one of the three firearms used in the shooting was located along with shells. Why is that not enough to make him a joint venturer in the shooting?
Well, the alleged threats were made at that April 17th shooting, and there was not uniformity as to the evidence concerning those threats.
Well, but we're viewing the evidence in the light most favorable to the Commonwealth, so the fact that it may not be credible is not for us to decide.
And here, it's a deficiency on the part of trial counsel, but it is my understanding, I know that the prosecution argued that he had a perfectly operable vehicle and still rented this van. I have information to the contrary, not part of the record, unfortunately, so.
How can we do anything with that, though?
But the fact that somebody rents a vehicle,
The fact that you rent a car when you have a car, isn't it a reasonable inference to draw that you're trying to conceal,
well,
you know?
it's to say, it's a hard argument for me because I have information to the contrary about the operability of the Volkswagen, but under the facts as known to the jury,
Right.
or at least the inference that the prosecution wants them to draw. But as far as his presence at the scene, he's not identified. He's found an hour later in a car that he rented as a passenger. There is nothing at the scene. There's no fingerprints. The casings that are found at the scene, there are some that are tied to the gun that's found in the back next to Carlos Silva. There's no fingerprints on that gun.
Well, isn't that enough?
Excuse me?
Isn't that enough, that the gun is used in the crime? Whether there's fingerprints or not, the shell casings and the murder weapon in the car?
It's not the murder weapon.
Well,
That was a misstatement of evidence by the prosecution, that
that gun wasn't used in the fatal shooting.
the bullets that were recovered from the bodies were not tied to that gun. There were some shell casings at the scene that were tied to that gun.
Okay, so this gun missed.
Yes.
Okay, that's kind of bad, isn't it?
Excuse me?
That's not good for your client.
It's not good.
All right.
But the question is, does it rise the level, especially in light of the fact of what the jurors' question was. The jurors' question was concerning presence. They wanted the court to give them some sort of idea of what constituted, how close he had to be present. So they were apparently believing Bobby Allen's testimony that he was not in that van during the shooting.
What one part in your brief I couldn't follow. Are you suggesting the gun was found somewhere else, not in the front passenger seat? Because the Commonwealth says the gun.
According to the transcript as I read it, the gun was found in the cup holder in the back near Carlos Silva, in the third back seat, the van having 3 seats. The driver and the passenger in the front and middle seat and the back seat, Carlos
Isn't
Silva.
testimony that supports the Commonwealth that the gun is found in the van in the front passenger seat?
That's not as I read the testimony. I read the testimony that it was found next to the Carlos Silva in the back, in the third back seat.
Okay, I think your time is up. Thank you.
Thank you.
Ms. Campbell, good morning.
Good morning, and may it please the court. Kaylin Campbell on behalf of the Commonwealth. With me today is the trial prosecutor in this case, Patrick Hagan. I'd like to start with a point not raised by my sister, but the Commonwealth made a mistake in its brief on page 28, in which it states that the defendant did not object to the cooperating witness jury instruction. He did, and that can be found on transcript volume 9, page 118. That does change the standard of review from a substantial risk analysis to a prejudicial error analysis. I don't believe that it changes the outcome that this court should reach, because I don't think that the defendant can prove that he was prejudiced by this.
But in the ordinary course, instruction regarding truthfulness shouldn't be provided unless that part of the cooperation agreement comes in, right?
I believe so. The defendant here did request it. It did come out. I disagree with my sister's representations about the cooperation agreement. They were entered into evidence subject to redactions. I included them in my record appendix. There's nothing in the record to indicate that the defendant objected to any redactions or didn't want these portions of the cooperation agreements to be entered.
So what was redacted from the cooperation agreement?
The redactions are located on pages 171 through 175 of the Commonwealth's record appendix. I'm not entirely clear as to what was redacted, but it's clear on those pages specifically what was redacted. The truthfulness portions are not redacted, though.
That was my question. Thank you.
Yes,
So they are there.
they are there.
So the judge probably should have given an instruction to say that the Commonwealth is in no better position than you are to evaluate truthfulness.
Yes.
So the question then is what consequence, what prejudice should arise, or what consequence should arise from that?
Well, while I say yes, I would point the court to Roman, which I cite in my brief, which I still think is the case that's the most instructive on this issue. Because in Roman, this court held that the failure to give that specific language wasn't an error. So they don't reach the prejudicial type of analysis. But even if you were to reach the prejudicial type of analysis, I think this case can be distinguished from Roman in that the 2 cooperating witnesses didn't give any testimony about the April 28th murder. They were simply giving testimony about the April 17th shooting, and this testimony was provided through other witnesses, including responding officers to the scene who heard the defendant's statements, and specifically Hamilton DeSoto, DeSoto, who was a victim of the shooting, was shot. He testified to much of what Jose Alves who testified to. Also, the person who is alleged to have shot in this case, Alfredo Goncalves, he also testified that he had pled guilty to shooting at Hamilton DeSoto and Jose Alves. So to the extent that they offered testimony, it was offered through other witnesses.
So that's another question I had. Usually, when I'm looking at the sufficiency and I hear there is a cooperating witness, I hear something said by the cooperating witness that goes to the weight of the evidence with regard to this shooting.
Correct.
But I gather the cooperating witnesses did not offer anything that went to the weight of, that went to the evidence regarding this shooting.
They did offer evidence that went to motive, which I think was
I'm referring to the earlier shooting.
correct. They offered evidence as to motive as to why the defendant would carry out the shooting. I think it's, in this case, a lot of the the incidents that happened on April 28th were tied back to what happened on April 17th.
But were they the ones who heard him say, I will, whatever the words were, I'll get revenge for you?
Nunes, no. Alves testified that he didn't hear it on the scene, but when he was in the hospital, he did have a phone conversation with the defendant who said something akin to, don't worry, they're going to get it. But I would say that the specific statements made by the defendant on the scene, I think it was Officer Marty O'Malley who testified that when he responded to the scene of the shooting, he heard the defendant say 15 to 20 times, somebody is going to die for this. So that testimony did not come through these cooperating witnesses. I'd like to turn now to the arguments made by my sister on the closed courtroom claim. And specifically, I want to clarify responses given as to the judge's factual findings. First, I'd like to note that she doesn't challenge that any of these factual findings were erroneously made in her argument in her brief. But setting that aside, I would point the court to Commonwealth Record Appendix pages 93 through 94. And what that is it is an affidavit by, it's a motion, a motion that was written by the trial ADA for a protective order, and it recounts the need for a protective order. And it specifically details the shootings that had happened. And I'd like to note that Judge Hinkle also was the judge who heard the motions for a protective order, so this was information that was known to her. But specifically, if you look at it, on page 93, paragraph 5, it says on June 13th, 2003, Carlos Silva, who is the cooperating witness that later went missing, was shot at with one of the co-defendant's sisters. Paragraph 6, on June 24th, 2003, gunshots were fired at the home of the co-defendant Henrique Lopes. Paragraph 7, June 26, 2003, Henrique Lopes was shot at. Paragraph 8, June 29, 2003, one of the co-defendants, Fernandes, was also shot. So those were all before the trial judge. They were all before the motion judge, who was Judge Inge and not Judge Locke, as my sister contended. And it absolutely, this was a motion that was filed in the records of the court at the time of trial. It's absolutely something that the motion judge could rely upon on making factual findings in the motion for new trial. But more so than that, I would say that Judge Hinkle's decision to close the courtroom is absolutely justified in this instance. My reading of Maldonado is the same as yours, Justice Gantz, that it was a partial closure, and when you're considering partial closure, you can look at the entire record for support for the judge's finding. I'd also like to note that this doesn't just come up at May 25th, as my sister contends. It comes up, Judge Hinkle is talking about security in no less than 6 pretrial hearings. The first time the list is brought up is May 11th, 2006, which is more than a month before the first day of trial, which is June 20th. Not only did the co-defendants have Attorney Sultan representing him, but they also had Attorney Scapiccio, and both of them are very zealous advocates who defend their clients' rights. So I think it's fair to say where Judge Hinkle is really at a loss and pleading with them for not only alternatives, but to take her up to the single justice. I think she says that to them. Please take me up to the single justice because I want to know what to do.
But we don't have a single justice requirement to secure one's rights. All they have to do is object, and they have a favorable standard of review. We don't say to the defense attorneys, you have to object and file a 211.3.
You don't, but I think Maldonado is instructive as to what a trial judge should do, and Maldonado does say that the determination should be made with sufficient time so that a 211.3 can be filed. And even though Judge Hinkle didn't have the advantage of having Maldonado or Ray, she does follow what is later, very many years later, set out as the course that she
Although
should take.
She goes further, right? They're doing criminal background checks.
As to, yes.
That seems, that's a significant step further for allowing someone into a courtroom, isn't it?
I agree. I agree.
So explain why that's appropriate exercise of her discretion.
Sure, I'd say it's an appropriate exercise of her discretion given the very real security threats in this case. And I would point to, not only was it gang motivated, you had co-defendants and witnesses who had been shot at. The defendant had his own safety concerns, which is borne out by the fact that he is immediately sentenced upon arrest to a different sentence, and he is expressing concerns about where he's housed in prison because he doesn't feel safe. The fourth is that there are multiple protective orders in this case related to disclosure and dissemination of the grand jury minutes. And if you look actually at June 20th, when the Commonwealth is forced to null pros the case against two of the co-defendants, Judge Hinkle actually takes the step of requiring defense counsel to give all of the grand jury materials back. Because
I get all the security concerns. I'm just trying to understand, did we have any, from the record, what do we know about how the criminal records were used? I'm just trying to...
The criminal records were used, I believe that two individuals were kept out on the basis of their criminal records. One was Jair Fernandes, who at one point was a co-defendant in this case.
The one who threatened the judge?
That's the defendant's brother, Odarison Fernandes.
Okay.
And the other one is Thomas Ross, who I believe was kept out because he had a number of violent-related crimes on his record. So there was a real concern that there would be disruption in this courtroom, that there would be witness intimidation. And I don't think that Judge Hinkle was required to wait for that to happen. Although it isn't indicative of her decision before trial, despite the...
She explained, and I haven't read the whole record yet, does she explain how she's going to use the criminal records to exclude? Is it if someone has a violent crime or if someone has a violent gang-related crime? I'm just trying to understand how they're going to use this information and what's the understanding about how it's going to be used.
Sure. It is discussed, I believe, both at the May 11th and the May 25th pretrial hearings. As to whether she provides specifically how it's going to be used, I don't remember. I apologize for that.
And how should it be used?
Well, I think it should be used the way it was used here, where you have individuals who have certain affiliations or crimes that are borne out through their record. I think it's entirely appropriate for any party to address concerns that they have about that. I think that this case, it cannot be downplayed, the very real and grave security threats that were apparent. And I think that's borne out through, I think part of the concern was that you can see this through two of the co-defendants, both Lopes, were not in custody at the time, and there were concerns about the fact if they weren't remanded every day, that they would be out in the halls, that they could be mingling. So I think the safety concerns go to that. If you have someone who has a number of assaultive or violent crimes, in this instance where you have co-defendants that could be out in the hallway, there was a concern that there would be, I think the judge specifically says mingling between them. So I'd say that where you have those very specific type of concerns based on the circumstances.
Do they need to be specifically related to the violence here, meaning that they've got gang-related fights, or does it, if you have any A and B conviction, you can be excluded from the courtroom in a case where we've got these kinds of gang-related concerns? I'm just trying to understand what the rule, how do you want this to read?
Sure.
If we're affirming it.
I think it needs to be fact-specific to this. I don't want to draw a bright line and say if you have one A and B, you're going to be kicked out of the courtroom. I don't think that necessarily would be an appropriate ruling. I think that what should happen is what happened here, where it was the prosecutor who asked that individuals be kept out, and that they state a reason based on the record why they believe that the record should disqualify them from being in the courtroom. I think then the judge can look at that reason and determine whether it meets muster.
If I can turn you back to the issue of the findings.
Sure.
I think you can probably expect that we're not going, well, I don't know what we're going to do, but I'm not likely to endorse one that says the mere fact that we're short of court officers and that it is a gang case is sufficient by itself to justify a partial closure. And I've not looked to see, but I gather the findings, the things you are describing are not incorporated in any formal finding
By Judge Hinkle?
by Judge Hinkle.
No.
So what do we do in that circumstance if the reasons given are too generic and too common to necessarily support what here was a rather substantial partial closure?
I would say what you do is what you do in every other partial closure case, and you look to the entirety of the record. I don't think it's fair to fault Judge Hinkle for the findings that she made, because it wasn't a complete closure, and under the case law, she's not required to make the same type of findings. I also think that where Judge Hinkle was the Raj at the time, where she had presided over all of these protective order motions, where nobody at the time that they were in front of Judge Hinkle was disputing the very real concerns that were created because this was a gang case. I don't think it is as simple as saying now, removed, all these years later, 11 years later, it appears that these factors that she articulated were too general.
And do we have in our record the motions that you described?
Yes. I appended them to my motion for new trial, so they were before the motion judge, and they're part of my record appendix. Specifically, I think they appear multiple times, but 93 to 95 were what I pointed out.
You had mentioned that. That's my
Yes.
mistake, yes.
Yes. I'm happy to answer any other questions that the panel has.
I had this confusion about where the defendant's gun is found.
It's found in the back passenger seat.
Okay, it's in the back passenger seat.
Correct. And it's found underneath the cup holder, and it's wrapped in a piece of paper from a manual that is a Volkswagen Golf manual.
He's in the front passenger seat.
He is in the front passenger seat.
Yeah, how do you wrap a gun around a page from a manual that you put in your glove compartment? I couldn't quite figure that out.
So the way, and I can move to transmit exhibits if you wish. They're photographs which are better, which I believed that I had included.
But that will describe what that would look like.
Correct. What these photos show, and they were entered into evidence, is that there's a manual sitting right next to the cup holder, and there's a page that's been torn out of the manual, and it's essentially just the paper is wrapped around the gun like that. But I will move to transmit those exhibits so you can see more specifically what it looked like.
And is the Golf manual of the same, I mean, it's a Golf, but it was at the same type and same year as the defendant's car?
I think it was more generally just a manual about Volkswagen Golfs, not necessarily the manual that you would get with your car when you purchased it.
I see, okay.
Burden shifting, the prosecutor keeps going, what would the defense have you believe repeatedly, right? So,
Yes.
I mean, like multiple statements of that. Why isn't that some suggestion? I mean, the defendant doesn't have to have you believe anything, right? So,
He doesn't. I'd say when you look at it in context as a response to defense counsel's closing argument, in which he over and over again says that the Commonwealth's case is based on nothing but speculation, it's more of a response to that. Defendant would have you believe X. The prosecutor then, in every single instance, goes and tells you why that isn't true, pointing to evidence, which I think is entirely appropriate. To the extent that it's not, there was an objection. The judge did say, I will deal with where the burden lies in my instructions. The judge then does instruct over and over again that it is the Commonwealth's burden to prove everything beyond a reasonable doubt. And the defendant doesn't object at the end of the judge's instructions, indicating that he had any problem with what the judge had done. So
the standard is it's objected to all the statements about what you believe, what would the defendant have you believe is they're objected?
They are objected to. But to the extent that the judge indicated that she would give a curative instruction, defense counsel indicated that he was okay with the judge proposed course of action. After the judge instructed, he didn't indicate that he needed anything additional from what the judge said. So I'd say that the judge's instruction, even if there were an error, which we're not conceding, was sufficient to cure that type of problem.
Last question, I should know the answer to this, but so all of the sort of improper comments about the criminal record, right? I'm remembering, they're done, I'll save it, forget it. I'm okay.
No, it's okay. I don't know what you're referring to, the criminal record.
No, I'm wrong. Don't-
Okay. And if there are no further questions, the Commonwealth urges you to affirm the defendant's conviction for the murder of Jose de Vega and his shooting which paralyzed Christopher Cavallo.
Thank you.